Hi everyone, and welcome to another Apple webcast. My name's Kyle Scott. I'm joined today by my colleague Kate Thomson, and today we're going to be discussing the very important issue of sexual harassment in the workplace. Kate, I think it's a timely discussion given what today is.
Absolutely, Kyle. So happy International Women's Day to everyone, if we can call it a happy day.
Absolutely.
But it is a topical discussion for today, and hopefully we'll be able to shed some light on this very important, interesting subject for everyone.
I mean, from my perspective, there has been a lot that's happened over the last 3 or 4 years, and there's a lot to unpack in that. What we might do, just in terms of an agenda, we're going to talk about some of that contextual stuff that I just referenced. We'll then jump through to the legal framework, and we'll talk about some of those kind of foundational, definitional issues. We'll then have a look at the recent legislative changes that have come out of a recent and very significant national inquiry and report. We then might talk through a few case examples and try and conclude with some observations or suggested practical steps for how to prevent sexual harassment in the workplace and how to manage those issues when they arise. Now, before we jump into it, Kate, we've got the iPad here, so we've got the ability to take questions live. So if you're watching now and you have questions, feel free to submit those and we'll try and deal with as many as we can. And I think on that note, we might jump into it.
Sounds good. Thanks, Kyle. So like Kyle said, we don't come at this topic from isolation. We come at it from a context and a history, I think, of about 4 or 5 years worth of these issues coming into the mainstream media, people coming forward with not only relevant and recent complaints, but also historical complaints. We see there Parliament House mentioned. Of course, we've had Brittany Higgins come forward with her allegations of being sexually assaulted. We've also got the historical allegations against Christian Porter from the late 1980s, which have come to light as well. Historically as well, we talk about the High Court. And I think the thing that really strikes me there, Kyle, is that we're not just talking about small workplaces with unsophisticated systems and processes in place. No. And I think the message for everyone there is that, these are issues which affect and impact workforces in places big, small, sophisticated and unsophisticated. So
absolutely. I mean, I can't think of 2 more prominent Australian workplaces than Parliament House and the High Court. And we've seen just in the last couple of years, issues that have been raised in both of those workplaces. So if that gives you any sense of the scale of the problem, then I don't know what else does. And I mean, from my perspective, I think I kind of trace it back to about 2017, I think, where the Harvey Weinstein scandal and allegations came out. And then I think into 2018, that kind of created this catalyst for change. We saw the Me Too hashtags. We saw issues and allegations come out here in Australia about very prominent people. And that's kind of, that has been quite a sustained public discourse or discussion about the issue from, 2017, 2018 to now, and the discussion's ongoing. So yes. It's quite amazing. I mean, in terms of news cycles these days with the media, to imagine it as, a situation where that issue has effectively had such sustained media attention, I think reflects the scale of the issue. So, Kate, do you want to touch on the Harriock report?
Absolutely. So in 2018, like Kyle was saying, we've got the context of the Harvey Weinstein scandal hitting Hollywood, a number of high-profile Australian examples, Don Burke being one of those. And both the Australian Human Rights Commission and the Minister for Women decided that obviously it was an important topic and one that was worthy of further investigation and review. So the Respect at Work inquiry, or the inquiry into sexual harassment in Australian workplaces, was commissioned, which has led us to the Respect at Work report. The scope of the Respect at Work report is very broad. It runs to 900 and something pages. And if you've read all 900 and something pages, then you probably don't need to listen to Kyle and I talk today. But what we'll do is we'll try and give you a bit of an overview. And the relevance of the report is to the topics we're talking about today integral, because what's come out of it is not just your usual lip service or a bit of window dressing. We've actually had some significant legislative reform that it's important for everyone to appreciate, know about and understand, because it might have very real implications for your workplace. So like I said, we did have a number of key recommendations coming out of that report, and I think these are important to appreciate in the context of some of the data that came out of that report. And I'll just touch on that briefly before I start to talk about the recommendations. So one of the things that really struck me, Kyle, was some of the statistics about the prevalence of sexual harassment. So in the last 5 years, 33% of employees or people who had been employed in that period reported having experienced sexual harassment. So that's 39% of women. And importantly as well, 26% of men reported having experienced sexual harassment in the workplace. And on that note, I would just like to pause at that point in time and say, look, we do talk about women. We talk about a particular subset of the working population here, but it's really important to remember and recognise that sexual harassment does disproportionately affect people who come from the LGBTQI communities, people with a disability, and people from a non-English speaking background. So as we move through some of these themes and legislative changes, if you resonate with any of those groups as having representation in particular in your workplace, probably pause to stop and think about some of that stuff as well. So like I said, we've got a couple of key recommendations coming out of the report. The first one there you'll see is amendment of the Sex Discrimination Act to firstly expressly prohibit sex-based harassment and then also broaden the scope of the existing prohibition of sexual harassment. So this has come out of the discourse around what is actually sex-based harassment, what sort of behaviours are we talking about, what sort of things that are we wanting to give people an avenue to address, which is the other side of the legislative provisions. We need to know what we're talking about before we can work out what to do about it. Importantly as well, the report has recommended the introduction of a positive duty on all employers to take reasonable and proportionate measures to eliminate sex discrimination, sexual harassment and victimisation as far as possible, also to give the Human Rights Commission greater enforcement powers, and also to extend the time frame on which the Human Rights Commission can terminate a complaint from 6 to 24 months. And this last one's particularly important because, as we've touched on, Kyle, people do come forward quite an extended period of time often after these things have happened to them. And whilst there's no technical time-based prohibition or time-based schedule in the sex discrimination legislation in which a complainant does need to bring a complaint, the Commission has the power or had the power to terminate those complaints if it was more than 6 months since the behaviour had occurred, which
that's right.
Realistically isn't a long period of time. No,
and I mean, if you think about sexual harassment in the same way that I might think about workplace bullying, quite often it's a series or it's a sequence of events over a period of time that might range in scale or severity from month to month. So it may not be on X date this happened to me and therefore the 6 month clock starts.
That's right.
It can be something that kind of goes on over a period of time.
Yeah, that's right. And also, importantly for us, the employment lawyers and employment law nerds, there were some important amendments to the Fair Work Act coming out of the report as well. The introduction of the ability to issue stop sexual harassment orders, and we'll talk a little bit more about that in detail later in the webinar. And also the inclusion of sexual harassment in the definition of serious misconduct. When we think about serious misconduct, we think about that capacity to terminate without notice. And that's a really important recognition that this behaviour can be sufficiently serious to be up there with things like theft, violence, and those other really concerning behaviours that we've just accepted as a society we don't want as part of our workplaces.
Absolutely. And I mean, there's 55 recommendations that came out of that report. There's a range of educational recommendations. There's recommendations about government and state authorities and bodies working together, forming councils so that there can be coordination from different regulatory agencies. I think there were, of those 55, I think there might have been about 13 that were legal recommendations, so recommendations around legislative change. So certainly that slide does not have all of the recommendations. We've focused on those legal recommendations for legal change. Now, we're going to talk about which of these recommendations have actually been implemented. The Attorney General's website at the moment has a table that was published a couple of weeks ago that has effectively a status update of each of those 55 recommendations and where they're at. So those that have been fully implemented, those that are fully funded but not yet implemented, and those where there's ongoing discussions or that the government hasn't indicated an intention to implement those recommendations. So we'll get to that shortly. I think the other thing that we'll talk about in quite a bit more detail is the introduction of the ability to stop sexual harassment orders in the Fair Work Commission. And I think the other thing just to note is we talked about the contextual, societal, where we're at as a society at the moment. Even yesterday, I think I read in the paper that it's a safety, respect, equity campaign. So there's 9 prominent female Australians who have come out, I think, to coincide with International Women's Day and to call for ongoing reforms to address violence against women and sexual harassment, and calling again on the government to commit to implement all 55 recommendations. So the report has those recommendations. Some have been implemented, some have not been, and it's an ongoing process. So I think if we probably don't need to talk too much more about the Human Rights Commission report, the Respect at Work report, but other than to just make this observation, which is my personal observation, which is that there's always a lot of reports coming out, there's Senate inquiries, there's different reports. This was a very significant report,
yes,
and it's clearly captured a lot of attention in the community, and it's nice to see recommendations that are now being implemented. So it is very significant compared to some of those reports that come out, 5 people read them, they get put in the top drawer and nothing ever happens.
never seen again.
That's right. So before we focus in and hone in on sexual harassment as a legal issue in particular, I think it's worthwhile just to talk about at a bigger picture the different legal causes of action or the different legal definitions, just so that we're all on the same page as to what we're talking about. So sexual harassment, we'll have a look at the Sex Discrimination Act and the definition of that, but we've got there up on the slide. Sexual harassment is unwelcome conduct of a sexual nature which a reasonable person might anticipate the possibility that the conduct would offend, humiliate or intimidate. So that's the statutory definition of sexual harassment. We then have discrimination. And so in Australia, there's a range of federal and state anti-discrimination pieces of legislation. At the federal level, we have the Sex Discrimination Act, the Race Discrimination Act, and the Disability Discrimination Act, the Age Discrimination Act, a bunch of different statutes. In New South Wales, as an example, there's the Anti-Discrimination Act. So we've got a little bit of a patchwork quilt of anti-discrimination statutes, but discrimination as a legal concept is the less favourable treatment of an individual based on a protected attribute. So in order for discrimination to be unlawful, it must be conduct that's based on that protected attribute. The attributes such as sex, marital status, age, race, religion, has to be protected at law. We then have probably mentioned workplace bullying. That's another pervasive workplace issue. The definition of workplace bullying is repeated unreasonable behaviour or conduct that creates a risk to a person's health and safety. And that's set out in the Fair Work Act. And then lastly, we've got harassment as a general issue. So when I'm referring to harassment, I'm not talking about sexual harassment, which is quite a specific legislated protection. But harassment generally has been a term that over the last decade I've heard people throw around. What's interesting, academically at least, in terms of talking about harassment generally, not sexual harassment, but harassment, is there's not necessarily any clear single legal provision in Australia that says you must not harass somebody. There are some federal and state provisions, including criminal provisions and civil provisions, that kind of touch on the notion of harassment. I know that there's criminal laws around stalking, intimidation, harassing someone over a carriage service,
Yes.
which is a phone, I think. Might be something else as well these days. So there are different criminal laws out there. We'll also talk about sex-based harassment, which is one of the new reforms in the Sex Discrimination Act. So harassment has a little bit more of a fluid legal definition. There's not a clear single definition. So just bear that in mind. And I think the reason I wanted to raise that is employers quite often will have discrimination, bullying and harassment policies. And I think that always makes me pause to say, well, when we say harassment, are we talking about sexual harassment or are we talking about harassment generally? And if we are, we just want to be careful about making sure that the policy deals with both sexual harassment and harassment. So hopefully that's helpful. Academically interesting to me, perhaps, maybe not many others. So then if we hone in on sexual harassment as a legal issue or a legal cause of action, again, what keeps us employed is the patchwork quilt of the legal framework that we have in this country. There's no single legal cause of action or legal or piece of statute that deals comprehensively with sexual harassment. So the primary piece of statute would be the Sex Discrimination Act, which is a federal piece of legislation. There is also in some states effectively mirroring provisions. So in New South Wales, the Anti-Discrimination Act. Those pieces of legislation prohibit and make it unlawful to sexually harass someone. I think that those statutes talk about different categories. So it says sexual harassment in the workplace or sexual harassment in the provision of goods or whatever it might be. So you have to go and check each of those pieces of legislation for the specifics, but we'll talk about that definition. But suffice to say, the Sex Discrimination Act makes sexual harassment unlawful. So that's the starting point. We now have Fair Work Act provisions that talk about sexual harassment and empower or provide a framework for a complainant to take a complaint to the Fair Work Commission and empower the Fair Work Commission to make stop harassment orders. And we'll talk about that. And we've probably alluded to it 4 times already, and we will get to it. Thirdly, we then have the Work Health Safety Acts in the various jurisdictions, states and territories and Commonwealth around Australia. And the primary statutory duty under the Work Health Safety Law is to take all steps reasonably practicable to ensure the health and safety of workers. So you can see how sexual harassment as an issue can become a work health safety issue.
Yes.
And I shouldn't say can become. I think a more accurate way of saying that is sexual harassment is a work health safety issue, because as an employer, if your duty is to take all reasonable steps or all reasonably practicable steps to ensure the health and safety of your workers, well, preventing sexual harassment clearly seems to...
One of those things.
There's a linkage there. You then have the workers' compensation schemes around the different states and territories, which provide a statutory compensation regime for compensable injuries. So if someone is the victim of sexual harassment and suffers an injury or an illness, then the workers' compensation scheme will come into play, most likely. And then lastly, and there's potentially others, but I think we've probably hopefully covered the field here. From time to time, you can see tort or contract issues coming into play. And I can kind of go back more than a decade now to the Christie Fraser Kirk and was it David Jones?
Yes.
Mark McInnes lawsuit, which was very prominent, front page news back then in about 2010, I think. And there was a lawsuit filed, and it was a sexual harassment matter, but the statement of claim didn't necessarily just plead breaches of the Sex Discrimination Act. It also argued that there was a breach of contract, and the argument was that the employment contract either expressly or impliedly imposed an obligation on the employer to provide a safe place of work. So there's scope to argue that if you're the victim of sexual harassment, the employer potentially has breached your employment contract. And then when we talk about torts, we're talking about civil claims like negligence. So again, just bear that in mind when we're talking about that issue, because the legal framework is like a lot of the times we talk about different topics, the legal framework is not necessarily that straightforward.
That's right. And just before we move on, Kyle, we might turn to a question, and it sort of picks up what you were saying there, a little bit of that David Jones kind of context and theme.
Yep.
What is your view of the strength of an employer's argument that they should not be vicariously liable in a circumstance where a perpetrator was in a role where they were knowledgeable of the policies and discipline staff within them? So if we've got, for example, an HR manager engaging in this sort of behaviour.
So my view, and this is based on experience of seeing cases come out over the last 12 years, it is very rare for employers to be able to successfully convince a court that they should not be vicariously liable. So generally speaking, if we just unpack that, vicarious liability is the principle that employers will be held liable for the acts of their employees. It's not, there are some fetters on that, but it's pretty broad. There's a defence for an employer against a claim that they're vicariously liable. There's a defence that they say, well, we took all reasonable steps to avoid that situation occurring. So conceptually, it seems to be a live issue that should, most reasonable employers who have policies in place, they have training, reasonably sophisticated ways of dealing with it, you would think that there'd be a reasonable shot that they say, well, no, Joe Bloggs over there went off the reservation, did something inappropriate that he knew he should not do or she should not do, and we've terminated their employment. There's now a claim. The claim should properly be brought against that individual and not the employer. But notwithstanding that kind of legal test, I haven't seen too many cases where an employer has been able to successfully argue that they should not be held vicariously liable.
Yeah.
And I think the reality is when courts are dealing with these matters, the employer's the one with the deeper pockets. So I think that as much as that's not enshrined in statute anywhere, I think that becomes a relevant contextual factor when courts are dealing with the matter. So, sorry, a long-winded answer to the question. I think it's conceptually available, but it's very difficult because, and it only takes the applicant to try and point to one thing that you should have done but you didn't to get around that kind of defence.
Holding employers to a very high bar.
Absolutely.
Like.
Yeah, absolutely. And I think the same about workers' compensation.
Yes.
In my mind, at least, in New South Wales, the thresholds or the bars for workers' compensation is not dissimilar to the threshold or bar to vicarious liability.
So that brings us to, I think, a good point to talk about. What are we actually referring to when we talk about sexual harassment? And one of the underpinning concepts there is that it is unwelcome conduct. It's conduct of a sexual nature, unwelcome conduct of a sexual nature, such as sexual advances. But there really is quite a broad category of behaviour which can fall into this overarching concept or actionable course of action. We talk about reasonable person in respect of a lot of these things. We talk about reasonableness when we talk about workplace bullying as well. But when we're talking about sexual harassment, we're thinking about that unwelcome conduct of a sexual nature that a reasonable person would have anticipated the possibility, and again, not a very high bar, that the conduct would offend, humiliate or intimidate the other person. So it's a pretty low standard, Kyle, of putting an expectation on people to really think about how their conduct or how their comments or their other behaviours are going to land with the other person. And whether someone looking at that situation, so our hypothetical reasonable person, would have thought that there was that potential to offend, humiliate or intimidate the other person.
I think that's right. And we've deliberately underlined the word possibility there. And I think that quite often when you do workplace training and you talk about this issue, I think that's the part that surprises a lot of people is if you think about that, it doesn't require a reasonable person to have been offended or to be humiliated or intimidated. It's purely that a reasonable person would have anticipated the possibility that conduct would offend, humiliate or intimidate. That's a very different test.
That's right. And it's important to know there as well, there's need not be an intention on behalf of that person engaging in the conduct to offend. It's really about or was there the possibility, regardless of whether the behaviour or the conduct or comment was intended in a joking, jovial, or even sometimes complimentary or flattering sense. The other final note on that slide that I'd like to just touch on is it doesn't need to be directed at someone. So it can include inappropriate comments in a conversation, a group message chat, or in a lunchroom of a sexual nature. It can also be things like the traditional example of hanging the calendar in the crib room that perhaps isn't as PG as we would expect in a modern workplace. So that might not necessarily be directed at a particular person, but that doesn't mean that kind of behaviour can't be sexually harassing in nature.
And so I'll make a few observations about this slide. So the first is intention, whether you intended to be complimentary or you intended to offend them, is not relevant. And that's the same in respect of workplace bullying. That's the same in respect of discrimination legislation. So for just about all of these types of issues, intention is an irrelevant factor. And quite often people who engage in these kinds of behaviours, when they're hauled in for disciplinary processes, they don't realise that, and they're very, very kind of taken aback about the fact that, the person took offence to it. It's legally speaking not relevant whatsoever. It might be relevant in terms of disciplinary processes, sanctions, things like mitigating circumstances, like it wasn't deliberate, it was unintentional, I display remorse. Those types of things are relevant to sanction, but intention is not relevant to whether or not the conduct amounts to sexual harassment. Second observation is that so intention is consistent across sexual harassment, discrimination and bullying. The last point, Kate, that you touched on, which is the conduct doesn't need to be directed at someone in respect of sexual harassment, that's different to workplace bullying, where the definition talks about repeated unreasonable behaviour directed at an individual or a group of individuals.
Yes.
So there is that difference there. And then the third comment I wanted to make was, if we have a look at that statutory test, so unwelcome conduct of a sexual nature with the reasonable person element, lawyers, we talk about objective test and subjective test. What's interesting with this statutory definition is there's a mix of both subjective and objective elements to this test. So the first element is, was the conduct unwelcome? Now that is a subjective test. I could say the most egregious sexually inappropriate comment to you, Kate, for example, and if you welcome the conduct, then no matter how horrible the comment was and the fact that 9 out of 10 other people might find it entirely offensive, if the recipient welcomes it, then it cannot meet that statutory definition. Now, that's not to say go out and do it, but that's subjective. The conduct of a sexual nature, so was there a sexual element to the conduct? That's an objective test.
Yep.
And then the reasonable person test is, again, an objective hypothetical. It's not about whether Kate was offended. It's about whether a reasonable person in Kate's position would have anticipated the possibility that the conduct would offend, hurt, or humiliate or intimidate. So we have a mix of subjective or objective elements to that test. You can see the reasonable person element is the possibility. So it's a very low bar. The unwelcome conduct is different because that is entirely subjective depending on the person who receives it. So I'm not encouraging people to engage in banter or that kind of conduct in the workplace, but equally I don't think we want a workplace where we're all too scared to say anything. But the point I just wanted to make about this is exercise judgment, and if you are going to engage in behaviour that a reasonable person would anticipate the possibility that the conduct would offend, then you are risking, when you engage in that conduct, you are going out on a limb and hoping that the person welcomes the conduct.
Yes.
And so you'd rather not be in that situation at all. But just thought it's worth unpacking that kind of combination of subjective and objective elements there.
That's a really good point, Kyle. And I think it comes into a comment, I think, or a point on the next slide potentially, where, and indeed it's there, the last point there. And often we see this where perhaps there's been a friendship, even perhaps a romantic or a sexual relationship between colleagues, which is not an unheard of thing, is quite a common way for a relationship to start, where behaviour might start as consensual but may become non-consensual over time. So that's important to recognise as well. I don't think the intention or the purpose behind this legislation is to discourage people from having relationships with their colleagues, whether they're friendly in nature, which is what you were talking about in terms of having that banter and that casual chat, or indeed romantic. It's just about putting some parameters around that to ensure that when that conduct occurs, the person with whom it's landing is actually welcoming that conduct or that behaviour.
Well, absolutely. It's imposing a degree of accountability on the person to exercise sound judgment in the workplace. And what people need to understand is that what you say to people at the pub or somewhere else in a social setting outside of work is one thing. What you say to people or do in a workplace is a very different thing. The workplace is regulated by relevant laws. Outside, obviously, in social settings, there are some laws, but just be mindful that you might work with friends, but that doesn't mean that you're in a social setting. You're still in a workplace.
Same rules don't apply.
And you see that it's quite often there's a question about connection between the workplace and how far that extends. So it's not uncommon to see these types of issues come up in Christmas parties and other social events. So just be mindful that if it's connected to the workplace, there is likely to be, and there is, a different standard attached to the conduct.
Yeah, that's entirely correct. A couple of examples there that we'll just work through, and then a really helpful question which might illustrate some of these points for us. So examples of sexual harassment can include those persistent unwelcome demands or pressure for sexual favours. This was something we saw in some of our cases that we'll talk about toward the end of the presentation. So perhaps there was some interest from one party that wasn't reciprocated, which is manifested in these suggestive comments or even that subtle pressure for sexual favours. Sometimes it doesn't even need to be, do this and you'll have an easier time of things at work, as was the case in one of our cases that we'll talk about. Sometimes it can just be those inappropriate questions, inappropriate requests, even jokes. Public display of lewd images or pornography, like I said before, the nudie calendar in the crib room, which, unfortunately is something that still does happen. I have had a client of ours tell us about something quite recently where that was still occurring. And, you do need to have some regard to the fact that even where you do have workplaces where that's traditionally been acceptable behaviour, time's moved on.
Yeah, absolutely.
And that's just not something that it might have been accepted. It might have been an okay part of the cultural paradigm in that workplace in time gone by, but we really just need to be doing better in terms of what we're expecting from our employees, and indeed what kinds of things we're walking past and accepting as managers and employers.
Well, absolutely. And we'll talk at the end about some practical steps to try and address and prevent sexual harassment in the workplace, and we'll talk about culture. If you have a workplace where there's calendars on the wall, you're kind of creating a particular culture that is not necessarily one where, I can imagine the scenario where an employee does something inappropriate and they're disciplined for it, and there's an unfair dismissal. Do you want to be the employer before the Fair Work Commission where the applicant, the sacked individual, says, oh, well, they had this policy, but they didn't seem to enforce it. For example, you should see all the stuff they've got on the wall. Do you want to be that employer?
No, that's right. Yeah. And I think important to recognise here as well, I think sexual harassment's on a continuum, it's on a spectrum, and this is one of the things that comes out of the Respect at Work report particularly strongly. It really is just a different type of violence against women or violence against the people to whom it's directed. So we need to think also about those other things, which are not just comments, photos, memes, emails, whatever you might put in that particular category, but also things like pinching, patting, touching, unnecessary, reaching across the desk in front of someone. Those sorts of behaviours can fall into this category as well. And I think those are the sorts of things which are getting toward that more objectively serious and actionable behaviour, but not to say that the rest of these things aren't, particularly concerning or concerning in their own right as well.
Yeah.
Like I said, we did get a question through, Kyle, which I think is a good illustration here. So one of our viewers has said, I've had a situation where an employee invited a team leader to her home, purchased gifts for this team leader, and then claimed sexual harassment when the team leader raised concerns about that staff member's performance, so the person that bought the gifts.
But, an assessment as to whether or not there has been sexual harassment based on all of the circumstances and facts. The fact that, the employee might have invited a team leader to their house or to, bought gifts for them, I don't necessarily think that means that when something else happens, it can't be sexual harassment. I think you need to look at each of it objectively. For example, if you're a team leader and you're invited to someone's house socially for drinks on a weekend and then you get a birthday gift from that person and then you engage in sexual harassment, unwelcome conduct of a sexual nature, I don't think there's a defence there to say, oh, but hang on, I was invited to their house and other things. I think each instance of, each concern is going to be looked at to determine whether or not it meets that statutory test. Now, it might be a case here that the employee raised concerns around sexual harassment as a response to legitimate performance or disciplinary concerns being raised, in which case, well, maybe there's no merit to it. But I think you just have to look at the specifics and unpack whether or not you meet that statutory definition or test. I think that's the answer.
Yeah, that's a good point.
I was just going to, you mentioned kind of patting and touching or pinching and things like that. I was just going to mention some of that behaviour may well amount to the criminal offence of assault.
That's a good point.
The criminal offence of assault is relative. I don't want to say it's a low bar, but it's not a really high bar as well. So if there's physical interactions between individuals in the workplace, in the same way that if there's a fight in the warehouse or a workplace, that may also amount to a criminal offence. So just bear that in mind as well. All right. So we've touched on the Respect at Work report. We've touched on the recommendations, the 55 recommendations that have come out of that report. We're now going to have a look at some of those recommendations, and particularly the legislative recommendations that have been implemented. I think this was last year. My memory's hazy.
Late last year.
COVID and things like that. You can't quite work out what year it is or what month it is. But there were amendments to both the Sex Discrimination Act and the Fair Work Act. Now, in respect of the Sex Discrimination Act, they have broadened the scope of persons against whom it's unlawful to engage in sexual harassment. So we're talking about workers in that broad sense, including interns and others, in the same way that work health safety legislation talks about workers, not simply employees. So that's one of the amendments. The other interesting development is, and I thought it was important to talk about those foundational concepts of sexual harassment and harassment generally. That one of the recommendations was that they amend the Sex Discrimination Act to make sex-based harassment an offence and make that unlawful. So that's now different to sexual harassment. It's a different test. And so you can see there, sex-based harassment is unwelcome conduct of a seriously demeaning nature by reason of the person's sex in circumstances where a reasonable person would have anticipated the possibility that the person would be offended, humiliated, or intimidated. And it's also not simply by reason of the person's sex. It's by reason of a feature or characteristic that appertains to their sex. So I talked about harassment being a kind of strange, there's no clear uniform single definition. This is another one where civilly they're now saying, well, harassment based on someone's sex is unlawful, as distinct from sexual harassment, which is that unwelcome conduct of a sexual nature. So just bear that in mind as well. Given that development, one would think it's appropriate for employers to update their policies, code of conduct, handbooks to reflect the change in law there. Now, the third one there is there's a new section in the Sex Discrimination Act, Section 47A, that makes it unlawful to engage in victimisation. So that is taking effectively adverse action against someone. I'm using that phrase loosely, not
in the
not
Fair
talking
Work
about
Act.
general protections. I'm talking about engaging and treating someone detrimentally because they have made a complaint to the Human Rights Commission or made a complaint to the Fair Work Commission or have threatened or proposed to make a complaint. So that's kind of closing out potentially a little gap in the legal system there to make victimisation unlawful.
So I think we talked about the extension of the time frame for complaints. So that's, again, not necessarily a strict limit. So if someone did have a claim or a complaint that went beyond that 24-month period, it doesn't necessarily mean they're automatically precluded from bringing a complaint. It just means that the Commission actually has the jurisdiction or the power to dismiss those complaints. But important extension from 6 to 24 months, particularly when we're thinking about the impact that sexual harassment can have on people. And you talked a little bit about that when we were talking about workers' compensation. We need to realise here that people aren't always automatically able or ever able in some circumstances equipped to bring a complaint when these sorts of behaviours have been their experience. The Stop Sexual Harassment Order, we've referred to it a number of times, so we might want to talk about that now. So similar in nature to the Stop Bullying orders that can be made by the Fair Work Commission. Basically, the important things to take away there needs to be an ongoing risk. So we need to have people who are in the same workplace, who are proximate to each other, because like Kyle said, we don't necessarily need people who are employees of the same business. We could have a volunteer, we could have an employee of a nearby business, but we do need to have that proximate risk, so ongoing risk. And again, like the Stop Bullying jurisdiction, no capacity for compensation, really just a remediatory jurisdiction aimed at fixing the problem in circumstances where an employee often doesn't feel like the employer has responded appropriately to their complaint.
And what it does is it's a relatively informal, low-cost avenue for an employee where there's an existing employment relationship. If they're not satisfied with the employer's handling of a complaint, or they want to challenge that in some way, or there's some ongoing concern, there's a relatively informal, quick, easy, cheap avenue for them to ventilate that matter before an independent tribunal. So I think I think we had this discussion about workplace bullying. So the discussion that we've seen happen around sexual harassment over the last 3 or 4 years, I feel like we had that discussion about workplace bullying in around 2010, 2014.
About 10 years ago.
Yeah, about 10 years ago, where there was some very serious cases of workplace bullying. I think there was Brodie's Law introduced in Victoria. There was an inquiry and a report, much like what we're talking about today, which then led to the Fair Work Commission jurisdiction in respect of workplace bullying. I think we're simply doing the same thing now in the context of sexual harassment. So as Kate said, there's no compensation orders, so it's not a compensatory jurisdiction. It's a jurisdiction where there has to be an ongoing employment relationship or ongoing threat of sexual harassment. And as Kate said as well, what's sometimes overlooked, both in respect of bullying and sexual harassment, is if the conduct is happening at work and there's a risk that the conduct will continue to happen, then the Commission is empowered to make orders, stop orders. It doesn't require the conduct to be being engaged in by a colleague.
That's right.
And one of the first harassment Fair Work Commission decisions that came out was actually a workplace where I think there was factory bays, 5 or 6 in a row, and the employee of one business alleged that they were being harassed by someone in the adjacent factory bay. So someone from outside of that workplace, well, not outside the workplace, but outside of that employer-employee business. So just bear that in mind as well.
A couple of other things to note here, and just I suppose in the context of recognising that there's many facets of sexual harassment, sex-based discrimination and harassment as well. Some of the other provisions of the Fair Work Act have recently been amended to recognise issues which happen to people who have children, predominantly women, but we're not using that term exclusively either. So people who have miscarriages, people who have stillbirths as well, extending the entitlement to compassionate leave for people in those circumstances. So that's another key development in this space. Yep. We haven't seen that much amendment since the Fair Work Act was introduced, but just something to be conscious of because unfortunately relatively common issues and something which might not have come across your desk yet.
Yeah, and I think, so just that third one, which is the definition of serious misconduct, I think that's what that third one is, talking about clarifying that sexual harassment can be conduct amounting to a valid reason for dismissal. Sorry, I was misreading the slide. We talked earlier about sexual harassment also amending the definition in the Fair Work regulations about serious misconduct, saying that sexual harassment can be serious misconduct or is included in that definition. The only thing I wanted to say about that was that definition is not exhaustive. It's an inclusive definition saying serious misconduct may include or includes the following, but it's not exhaustive. So just bear that in mind.
That's a good point. So we'll talk now about a couple of case studies. I think if you'd like to talk to this one, Kyle.
Yeah, so we've got a few and I'm just conscious of time. So we might move pretty quickly through the 3 cases and then move on to the discussion around what businesses can practically be doing. But Poniatowska and Hickenbotham, now, excuse me, reasonably old case, not a recent case, 2009. But the reason this is a significant case, or one of the reasons, is the quantum of the damages that was paid. So without going through all of the facts and circumstances of the matter, there was allegations that the employee was subjected to very inappropriate comments, propositions for sexual favours or sexual relationships, etc., being kissed on the mouth by the managing director, which was not found to have occurred. That was an allegation that wasn't proven. And then I think when the employee raised the matter with a female superior within the business, the response was, well, what do you expect with a face like that? So we're talking about that type of conduct. A claim was brought in the federal court. The employee suffered quite serious psychological injury as a result of the conduct. The claim was brought. Obviously, all of the facts and circumstances were hashed out. The court made findings of fact, found that there was sexual harassment and sex discrimination as well, and assessed damages based on past and future economic loss as well as general damages and other things, and came to the sum of $466,000. And I think from time to time, businesses and employers will take a risk management approach, but it's not uncommon for businesses to kind of come to us as lawyers and say, look, I'm dealing with this matter. What's our exposure or what's the potential liability? I know a lot of clients, when they're talking about unfair dismissal, come at it from the angle of, okay, worst case scenario is reinstatement or 6 months compensation. Historically, as the next case talks about, historically damages were relatively modest. And so just bear in mind, we're not talking about a statutory cap of 6 months pay in respect of sexual harassment claims. The damages there was nearly $500,000. And the employer appealed that decision to the full court and the appeal was dismissed.
It's a really good segue into our next case, I think, Kyle. And again, one of the headline cases in this jurisdiction.
Yeah.
We don't have that many, and that's important to note as well, because a lot of these cases do get settled before they reach formal determination, which means that we don't really get to have an understanding of what the outcome is, the quantum of the damages. And in fact, non-disclosure agreements is another issue that came out in the Respect at Work report that we don't have time to talk about today, but is something which we might see some further development about, people talking about what happened to them after they have resolved a matter.
Yep. Here,
I think we had one of the first really important recognitions in the full court that the award of damages to Ms. Richardson in the first instance was just manifestly inadequate, having regard to not only the conduct that she suffered or that was directed toward her, but the implications that it had for her life, not only from an economic perspective in terms of the loss of wages and loss of income that she had after she resigned from her employment, but also just in terms of her personal life and her health as well. So here we had a 6-month period of harassment, colleague to colleague, just some really inappropriate comments, comments about sexual relationships, comments in front of clients and other people as well, that ultimately led to the plaintiff resigning in this case. But in the first instance, was really awarded, I think, pretty paltry damages in the amount of $18,000, which was ultimately appealed, and on appeal, as you can see in the slide, there was increased to $100,000. Like I said, because the court recognised that was really just out of step with what our expectations were and the impact of this particular course of conduct on this person's life.
I think that's right. I think the first instance assessment of damages was paltry, but was generally consistent with damages sums paid up in court decisions up to that point. This really was that watershed moment where the court said, well, hang on, $20,000 to $30,000 or thereabouts for this type of conduct is not sufficient.
No.
And so that was that watershed moment from which we're now seeing cases with far more significant damages.
That's right. And we have here on the next slide a recent decision, 2020, another shining moment for the legal profession, Kyle. Unfortunately, we feature far too often in this jurisdiction. But we have here, again, a senior person, like in the first case that we were talking about, really subjecting Ms. Hill, get your names correct, it's important, to a really, really inappropriate, demeaning course of action that obviously has had a significant impact on her professionally and personally. So, we've got highly inappropriate emails, conduct like demanding hugs from her whilst wearing his underwear on a work trip, and in circumstances where the plaintiff, Ms. Hill, actually raised her concerns with her employer on a number of occasions.
Yep.
And the response that she received was part of the course of harassing conduct, in that the employer came back to her and said, well, essentially, if you don't want to have any more problems at work, you can just sleep with me and that'll fix those problems. So really, really unsatisfactory, unsavoury course of events happened here. In the Federal Circuit Court, Ms. Hill was awarded, quite a significant amount of damages in the amount of $170,000, which was appealed by her former employer on a number of grounds, as you can see in the third dot point there. And perversely and perhaps very strangely, part of the appeal was that the circumstances were analogous to Pride and Prejudice. He likened himself to Mr. Darcy in his characterisation of the behaviour. And you can see in the fourth dot point there that the court on appeal found that the facts of the case are about as far from a Jane Austen novel as it is possible to be, given that he had exposed his employee to almost intolerable stress in circumstances where he had a profound and significant power imbalance over her that he actually exploited. His appeal was dismissed. I believe there were or potentially are some ongoing professional conduct implications for Mr. Hughes as well.
you would expect that.
That's right. So, another recent example, I think we're going to see more and more of these, unfortunately.
Yeah.
And it's just a timely reminder there that not only are the ramifications for businesses potentially significant from a loss of productivity, workers' compensation, and other more hidden cost perspective, but also you can end up in these circumstances where there's a significant award of damages, not to mention the embarrassment and reputational damage of having your business dragged through a case like this.
Absolutely. All right, so we might finish up talking about some practical steps that employers can take to try and identify, manage and reduce the risk of sexual harassment. So if we start with just a little bit of bigger picture in terms of the different types of areas that an employer or a business can focus on, I think the idea is to build a respectful workplace culture where this behaviour does not happen, and then to get rid of it if it does happen.
Yes.
and deal with it appropriately. So just at that kind of higher level, education of the workforce is clearly important. People need to understand what sexual harassment is, what sexual harassment's not. We see policies that provide examples of sexual harassment, which is very helpful. So having that education piece at the outset is clearly very important. Then setting clear standards or expectations of behaviour. I mentioned policies about doing that. People need to know what sexual harassment is. They need to know that it's not okay.
Yes.
And they need to know that if they engage in that behaviour, there will be disciplinary action up to and including termination of employment. If you haven't done that and clearly set that out for your workforce, then you should do that. The third step is to have people who are role modelling these types of behaviours. And a lot of this, there's no single solution to this pervasive issue. There's no magic bullet. It's going to be a range of different things at the workplace. But we're talking about building a culture, a particular culture, and having leadership and having role modelling. So I think that's really important as well. There might be some practical things you can do around frontline leadership training to have those line managers or middle managers or senior managers role model the appropriate behaviours and call it out when they see something that's not appropriate. Fourth, and I think this is a really significant point, and it's born out of that Respect at Work report, which is businesses need to be providing a supportive environment. The Respect at Work report and other publications out there that are very helpful talk about focusing on a victim-centred or a complainant-centred approach to dealing with the issues. So you don't want a scenario where it's happening at the workplace level and people don't know how to deal with it, they don't know who to speak to about it, there's no clear process, or they don't feel supported and empowered to raise it. So I think businesses should be particularly looking at that area to ask themselves, what can we be doing so that employees feel comfortable to raise the issue? And then lastly, addressing the issue appropriately and promptly clearly is very critical to trying to prevent it happen and to allow people to continue on with happy and productive work lives.
That's right.
So I then think in terms of putting some meat on the bones there, Kate, did you want to run through this one?
Sure. So like Kyle said, role modelling those behaviours, if I can say it properly. So setting the tone from the top, having your senior leaders, your middle leaders actually personifying and embodying the behaviour that you want to see from everyone, and being active when they see things that, perhaps are skirting the line of what we want to see or what might be appropriate. Focusing on a diverse and inclusive workplace, that's super important.
Yeah.
And like I said, there's some groups that are unfortunately disproportionately affected by these sorts of behaviours. We want to make sure that we're having a diversity of experience, diversity of background in our workforces, and that will help to reduce the likelihood of any one group being particularly targeted.
Yeah.
Finally, we say policies and procedures all the time, Kyle. I suspect people get very sick of it. And
I also think a lot of lawyers or consultants talk about it as a way of drumming up business. Have you checked your contract? Have you checked your policy? We're not doing that here. We're actually making some sensible or important comments about the need to actually ensure that you have these policies
That's right.
and why you should have them.
Yep. And not only that you have them, that they're actually accessible and communicated
Yep.
to your workforce. There's no point having a really schmick basket or bound document that sits in a crib room or someone's office that never sees the light of day, because, you know, ultimately they're not worth the paper they're written on if people aren't familiar with them, what your expectations are, and also that they're consistently applied.
Yep. And I think consistent is, it's one thing to have the policy, have it communicated, have it accessible. The consistent application is another thing. And you see in unfair dismissals, an inconsistent application of a particular policy will come back and bite you as well.
That's right.
Jumping through the next slide, policies are helpful for all the reasons that we've mentioned. Supplementing that with regular workplace training, where you can actually have a 2-hour session or a 1-hour session or a half-day session with the workforce or groups, where you work through these issues so that you ensure that people properly understand what the expectations are. Again, if you're dealing with an unfair dismissal claim or something like that, to be able to demonstrate that not only you've got the policy, but Joe Bloggs was trained on that policy 2 years ago, that again is very helpful to defend a claim. We've talked about that pathway for reporting concerns. Think about what your pathway is, how you can make it kind of more accessible or make people feel more comfortable. Do you have dedicated contact officers who have had specific training on how to deal with these types of concerns? Have you got an anonymous hotline, a bit like a whistleblower service? Those types of things will only help to encourage people to raise those matters. I've talked about that victim-centred approach of support services. So when someone raises an issue or complaint, what are you doing at that humanistic level? What are you doing to support that person? And I think that, you know, as a lawyer, I think about workers' compensation type claims, where if someone makes a complaint, it's not handled particularly well, they don't feel supported, it can very quickly end up in an injury and a claim for the company. So just bear that in mind. We've probably run out of time to spend much more, to talk much more about this, but I think some of the things we're seeing as well are this issue is being talked about at a board level more and more. And so from a governance perspective and a board perspective, are we measuring? Are we reporting on these? What, you know, boards like to have metrics on how they're tracking against a range of different criteria. You're tracking financial performance, you're tracking other things. Are you tracking how many cases you're having and how they're dealt with? So think about some of those things. Kate, I suspect that we've run out of time.
We love it. Plenty to talk about here,
Absolutely.
Kyle. But we'd love to have you along. We've got a sexual harassment in the workplace training course. Some of you may have attended some of our other courses previously. It's on the 11th of May. There's a link there that you can visit to book. And we also have another webcast in early April, Managing Leave. We've got lots of resources, lots of newsletters that come out every week. You know, lots of things always happening in this jurisdiction. So we'd encourage you to sign up. And there's some contact details there as well if anyone has any particular concerns or issues that they'd like to discuss.
Absolutely. All right. Well, thanks everyone for joining us. Until next time, have a good day.
Thanks.